As of 7 December 2022, you can no longer stop employees talking about their rate of pay, and you can no longer include clauses in their contract to stop them from doing so. There's two big consequences from this. First, if your contracts include these types of clauses, you may end up being prosecuted and having financial penalties against the company. But perhaps a bigger consequence is the fact that if your employees start talking about their pay and they find out that people doing the same work or similar work are being paid differently, it might lead to employee dissatisfaction. That in turn might lead to loss of trust, decreased morale, increased turnover, and potentially worst case scenario, some kind of legal claim if, for example, an employee believes that the reason for their difference in pay is because of some sort of discriminatory reason like gender. Hi, I'm Jo Alilovich. I am the Director of 3D HR Legal and the author of Home Force. And today I'm sharing the first in 3 videos we are producing regarding the recent changes to the Fair Work Act. And this one is all about the pay secrecy laws, what the changes are and what you as a business owner need to do about them. So for years, it really has been the norm to include a clause in a contract to say, you won't talk about your pay with any other employees, it's private, it's confidential, and usually there's a little reminder every time there's a pay review to make sure that you remember that you shouldn't discuss it with anybody else. All of that is now changing with these pay secrecy prohibitions. There are 3 key changes that have been made to the Fair Work Act. The first one is the fact that employees now have what's called a workplace right to discuss and disclose their pay, terms and conditions, or the terms and conditions that would help someone determine what their pay rates are. The second thing is that any existing contracts that have a clause in them that says you won't discuss your pay, well, those clauses become invalid. So even if you had that term, it doesn't have effect anymore. The third thing is that employers are prohibited from including these types of clauses, these pay secrecy clauses, in their contracts. And if you do, then there are potential financial penalties that can be ordered against the company. So what should you do about this? Well, there's probably 3 things that we suggest. First of all, start with your contract templates, review them. Do you have any of these pay secrecy clauses in them? If so, remove them so that before you go hiring any new staff, you are confident that you are providing them with a contract that is lawful. Second tip would be to review all of your existing pay rates. You need to check everybody in the organization, look at their pay rate, look at their level, their position, their years of experience, and make sure that they are equitable and that where there is discrepancies between one person and another, particularly where they are doing similar work, that you have solid grounds for explaining why there is that discrepancy. Third thing, consider how you determine your pay rates. Is there some sort of process that you go through, or is it literally just if someone walks into your office and says, I think I should get a pay rise, that you are making a decision at that point in time? It's really good to have a clear system in place so that you know on what grounds you are going to give or not give pay rates to people. To find out more about this Fair Work Act change and the other, you can see the rest of our videos in the series, or you can go to our website, 3dhrlegal.com.au, where we have a detailed blog on all of the changes. We also have a checklist there with a full list of all the things that we recommend that you do to get up to date to prepare for these changes.